Chapter 9 On the Business of Banking. 1. We have seen in a former chapter that from the time the word banker was first used it meant a person who bought money by means of his credit, or promised to pay an equal sum either on demand, or at some future time. In the business of the exchanges, those are termed banking operations which consist in buying and selling bills. A banker also buys other debts such as bills of exchange by means of his own credit, by creating fresh debts. Hence the business of a merchant is to buy and sell commodities with money and debts. The essential business of a banker is to buy money and debts, by creating other debts. A banker is therefore essentially a dealer in debts, or credit, though he sometimes adds other species of monetary business to this. In modern practice a banker may stand in four relations to his customer: 1. As the purchaser from him of money or debts. 2. As his agent or trustee, or bailey of his money in valuable securities, that is securities for money and convertible securities, these are termed banking securities. 3. As the pawnee of the same. 4. As his warehouseman for plate, specie, jewels, deeds, and c. Not being banking securities. The duties, rights, and liabilities between a banker and his customer are separate and distinct in all these relations, and we must now explain them. On the relation of a banker to his customer as the purchaser from him of money or debts. 2. The first of these cases is the ordinary one where a customer opens an account with a banker by means of paying in money to his account. In this case, the customer cedes the property in the money to the banker, and receives in exchange the right or property to demand an equal sum when he may require it. The transaction is a sale or an exchange of money for a debt. The money placed with the banker is not a depositum but a mutuum. The banker and his customer stand in the common law relation of debtor and creditor. It is also part of the fundamental contract between the banker and his customer that the latter may transfer this right or property, called a credit or a debt, to anyone else he pleases, and this right of action may circulate exactly in the same way as money itself. The banker therefore has bought this money, he has acquired the entire property in it, and he may do what he pleases with it. He may trade with it in any way he pleases, and his customer has no legal ground of complaint against him. He has voluntarily parted with his money and received in exchange for it the right to demand an equivalent sum, and if when he does so, his banker is unfortunately unable to pay it, the customer is only entitled to receive a proportion of the banker's property ratably with other creditors. Therefore the common phrase when a man says he has so much money at his banker's is incorrect. He has no money at his banker's, he has nothing but a right of action to demand money which is recorded in his banker's books, and which is called a deposit. If a customer makes his will bequeathing all his ready money, 6 all his debts, all his monies, the sum standing at his credit in his banker's books has been held by numerous decisions in equity to pass under these designations. The relation between banker and customer being simply that of debtor and creditor. If a customer were to leave a balance on his banker's hands for 6 years without operating on it, the statute of limitations would take effect, and he might if he chose refuse to pay it. This is the simplest case of an account between banker and customer and is called a drawing or current account. Trading customers however usually keep a different kind of an account with their banker. They sell their goods and take a bill at 3 months for them. As this bill is not convenient for trading purposes, they take it to their banker and offer it to him for sale. If he thinks it a good debt which will be paid at maturity, he buys it from his customer. He writes down to the credit of his customer's account the full amount of the bill, and at the same time he debits his account with the sum he agrees to receive as profit. When the profit is retained at the time of the advance it is called discount. The discount is, therefore, the difference between the price of the bill and the amount. When a banker buys a bill in this manner he is said to discount it. When a banker discounts a bill for a customer or buys a debt which is due to him, it is a complete sale of the debt. The banker first makes his customer endorse it, that is, write his name on the back of it. By this endorsement the customer, though he has sold the debt to the banker, remains a security for its due payment. And if the acceptor or principal debtor does not pay the bill when it becomes due, the banker has the right to charge his customer with the amount of the bill, provided he gives him immediate notice of dishonor. When a banker discounts a bill, the entire property in it passes to him, just as we have seen above. the entire property in the money paid in by his customers passes to him. The bill belongs to him just as much as any other chattels he possesses. He may sell it again if he pleases, or discount it, as it is termed, and if he becomes bankrupt, the entire property in it passes to his assignees. It is of great importance to observe the true nature of the transaction. In the loose language in which economical subjects are usually treated, it is commonly said that when a banker discounts a bill for a customer, he makes him a loan on the security of the bill. This, however, is a complete misconception of the nature of the transaction, and it can easily be shown to be so. If the banker merely made a loan to his customer on the security of the bill, it would be the customer's duty to repay the money at the time fixed, just as in all other loans it is the duty of the person receiving the money to repay it. But when a banker discounts a bill, it is wholly different. He does not seek repayment of the money from his own customer, but he demands payment of the debt from the acceptor of the bill, and if it is duly paid, his customer never hears of or sees the bill again. It is only in the event of the non-payment of the bill by the acceptor that he comes back upon his own customer. If he made a loan to his customer on the security of the bill, he would give the bill back to his customer when he was repaid, but he never does so when it is duly paid. In such a case the property in the bill would remain with the customer, and pass to his assignees in the event of his bankruptcy. Whereas it does not do so, it is the property of the banker, and the assignees of the customer have no right to it. The transaction is in reality an exchange of debts. The banker buys a debt payable at a future time, by creating a debt in his customer's favor, payable on demand. It may seem to some to be mere logomachy to distinguish between a discount as a sale and as a loan on the security of a bill. It is however nothing of the kind. The two transactions are essentially distinct, and involve distinct legal consequences to all parties, of the most important nature, civil, as well as criminal. As a matter of fact, the whole difficulty in understanding the nature of banking arises from the circumstance that those who have written on it were not sufficiently acquainted with the elementary principles of mercantile law. A debt is, as we have several times pointed out, a saleable commodity or merchandise, goods, or a chattel, like any other. The banker buys this chattel or goods, or merchandise from his own customer, at a lower price, and sells it to the acceptor at a higher price, just as any other retail dealer buys goods at a lower price from one person, and sells them at a higher price to another. And these goods are capital to the trader because he makes a profit by buying and selling them. Exactly in the same way the debts which the banker has bought and keeps in his portfolio, are capital to him, because he makes a profit by buying and selling them. And he buys these goods by creating a debt in exchange for it, for which he charges exactly the same as if it were cash. Consequently his credit is capital to him, just as if it were money. In these cases, therefore, which are the simplest, the banker does not stand in any fiduciary relation to his customer. They are independent exchangers, or buyers and sellers, of money and debts. On the relation of a banker to his customer as his agent or trustee, or bailey of specie and banking securities. 3. Besides, however, the simplest and most ordinary relation between bankers and their customers, as exchangers of money and debts. Bankers do undertake trusts, and enter into fiduciary relations with their customers. They receive sums of money which are specifically directed by their customers to be appropriated to some special purpose, as well as securities, and other valuable property, such as stock, shares, and to receive the dividends, on behalf of their customers. They receive bills of exchange on behalf of their customers, and collect them for their customers exactly in the same manner as they do for themselves, and are answerable to them for any loss incurred through any negligence in not complying with the known usages of commerce. Bills of exchange, stock, shares, exchequer bills, and are called banking securities. In such cases as this, the property in these valuable securities does not pass to the banker. He is the mere agent, trustee, or bailey of his customer, and he has to obey his specific instructions in each case, and if he appropriated them to his own use it would be criminal. Moreover, in the event of his bankruptcy, the property in such things would manifestly not pass to his assignees. The temptation to a banker to use for his own benefit the valuable securities entrusted to his care, is so great in times of commercial pressure that it is enacted by the Larceny Act 24 and 25 Vict. 1861, c. 96, s. 75 as to frauds by agents, bankers or factors. 75. Whosoever having been entrusted, either solely or jointly with any other person, as a banker, merchant, broker, attorney or other agent, with any money, or security for the payment of money with any direction in writing to apply pay or deliver such money or security or any part thereof respectively, or the proceeds or any part of the proceeds of such security for any purpose or to any person specified in such direction, shall in violation of good faith, and contrary to the terms of such direction in any wise convert to his own use or benefit, or the use or benefit of any person other than the person by whom he shall have been so entrusted, such money, security or proceeds, or any part thereof respectively, and whosoever having been entrusted either solely or jointly with any other person as a banker, merchant, broker, attorney, or other agent with any chattel or valuable security or any power of attorney for the sale or transfer of any share or interest in any public stock or fund whether of the United Kingdom, or any part thereof, or of any foreign state, or in any stock or fund of any body corporate, company, or society, for safe custody, or for any special purpose without any authority to sell, negotiate, transfer, or pledge, shall in violation of good faith, and contrary to the object or purpose for which such chattel, security, or power of attorney shall have been entrusted to him, sell, negotiate, transfer, pledge, or in any manner convert to his own use or benefit, or the use or benefit of any person other than the person by whom he shall have been so entrusted, such chattel or security, or the proceeds of the same, or any part thereof, or the share or interest in the stock or fund to which such power of attorney shall relate, or any part thereof, shall be guilty of a misdemeanor, and being convicted thereof shall be liable at the discretion of the court, to be kept in penal servitude for any term not exceeding 7 years, and not less than 3 years, or to be imprisoned for any term not exceeding 2 years, with or without hard labor, and with or without solitary confinement. On the relation of a banker to his customer as pawnee of banking securities. 4. In the first of the relations between the banker and his customer above described, the banker was the absolute purchaser of the money and securities of his customer, so that he might do what he pleased with them. In the second he was merely his customer's agent, and it is highly penal for him to appropriate to his own use any of his customer's securities. A relation between these two is frequently created in which securities are deposited by a customer with a banker. The absolute property in them remains with the customer, but he obtains a loan, or advance of money from his banker on their security, which when he pays off, the full property and possession of his securities reverts to himself. The banker thus becomes the pawnee of his customer's securities, and while he is so he acquires certain rights over them, though not exactly a property in them, and it is out of such cases as these that the most difficult and abstruse questions arise between bankers and their customers. It has always been the custom that if a banker makes a loan to a customer on the security of bills and c. deposited with him, he has the right to repledge, or sell so much of these securities as is necessary to satisfy his own claim. And this custom is expressly sanctioned in the same clause as has been already quoted. It says that nothing in the section shall restrain any banker from selling, transferring or otherwise disposing of any securities or effects in his possession upon which he shall have any lien, claim, or demand entitling him by law so to do, unless such sale, transfer, or other disposal shall extend to a greater number or part of such securities or effects than shall be requisite for satisfying such lien, claim, or demand. This principle has always been held to apply when a banker makes a loan on the pledge of these securities. It is also held to apply when a customer having an ordinary account with his banker has overdrawn it, and become indebted to him. The banker has a lien or a right to retain all banking securities deposited with him by his customers. But he has no lien against a customer for a balance of account upon valuable property, such as a chest of plate deposited with him for safe custody, not in his capacity of banker. And if a customer being indebted to his banker on overdrawn account, brings fresh securities to him, and directs him to appropriate them to some specific purpose, the banker has no lien upon them for his debt. He must either fulfill his express instructions, or return the securities to his customer. Nor has he any lien upon securities which his customer may deposit with him merely in his character as trustee. Even though the customer may have fraudulently obtained an advance on them from the banker, the trust will override the lien. But a banker's lien on securities which come into his hands without being appropriated to any specific purpose, or entrusted to him for safe custody, or the like, is so strong that it applies to bills or notes payable to bearer, to exchequer bills which pass by delivery, even though the customer were not the real owner of them, and had no right to pledge them. Questions of great nicety frequently occur between bankers and their customers, and in the event of the bankruptcy of either or both of them, their assignees, respecting the property of bills placed by customers in the hands of their bankers for various purposes. It is very common for customers to place in the hands of their bankers the bills they receive in business for the purpose of collection. This is very convenient for the customer. By placing the bill in the hands of his banker, he frees himself from all anxiety and trouble regarding its loss, or presentation for payment. The banker is bound as his customer's agent to present it for payment, and place the amount to his customer's credit as soon as it is paid. And if he fails to do so and any loss occurs through his neglect of the usages of trade, he must make good the loss to his customer. For the sake of convenience, it is usual to note down the amount of such bills on the proper day, in the customer's account in a column 6 short of or before the column for cash. Hence these bills are said to be entered short, and the banker is said to hold such bills short. The entry is a mere memorandum to remind the banker that he has such bills to collect for his customer, on a certain day. The sum is in no way placed to his customer's credit, and the bills held short are the exclusive property of his customer, which he is entitled to demand back at any time previous to his bankruptcy. As the banker has acquired no property in them, in the case of his bankruptcy, the customer is entitled to demand them back immediately. But in the case of the customer's bankruptcy, the banker must not deliver up his short bills to him, as all his property has vested in his assignees. As short bills are not the property of the banker, he would be indictable if he used them for his own profit. London bankers act as agents and correspondents for country bankers. Therefore they are in many cases, as regards country customers, the agents of an agent. A country customer frequently requires his banker to perform some duty for him which can only be done by his London agent, and perhaps sometimes that can only be done by that London agent employing a foreign agent. In these successive agencies losses may happen quite innocently in the course of trade, but in all such cases the country banker is liable to his customer because it was he who chose the agent who made the loss, or he chose the agent who chose the agent who made the loss. Therefore it was the country banker's conduct that led to the loss, and he must bear it, so far as regards his own customer, and then have recourse against his own agent. Hence in all cases when a banker undertakes to get payment of a bill, or anything else, for any party, he is liable to him, if any loss occurs through him or his agents. If a banker takes goods as a security for an advance, he ought to satisfy himself that his customer is entitled to them, for by common law the real owner will be able to recover them, or their value from him, if unlawfully pledged. That is, they have no currency. A banker sometimes takes a policy of life insurance as a security for a debt. In such a case he should give notice to the office of the assignment, as in the event of his customer's bankruptcy, the policy would vest in his assignees. It is a well-established principle that a debt due to a trader, though assigned by him, is in his order and disposition in the event of his bankruptcy, even though the instrument of the debt has been delivered over, unless notice of the assignment has been duly given. He must also have actual possession of the policy, as if the debtor holds it, it would pass to his assignees. Policies of life insurance are most undesirable securities for a banker to hold, as he may become liable to pay the premium for a long series of years, and may thus make a loss. But more undesirable still, if possible, are shares in public companies. To complete his right to them, he must have them transferred to himself, and thus become liable for calls, and even worse, in the event of the failure of the company. A banker, therefore, should never make advances on shares, except of companies of a very high standing, for instead of buying a security he may very probably find he has bought a liability. Doc warrants and bills of lading are negotiable instruments, and being duly endorsed, the property in the goods they represent passes by the simple delivery of the instrument, so as to empower the holder to obtain possession of them. A banker sometimes takes a deposit of title deeds, by way of equitable mortgage. In all such cases he should have a written memorandum stating distinctly the purpose for which the deposit is made, for it is laid down that in doubtful cases, where there is no memorandum, the court leans against considering the deposit as a security for antecedent debts. On the relation of a banker to his customer as warehouseman of his plate, jewels, specie, deeds, and c. 5. Besides buying money and securities from their customers in the way of banking business, bankers also receive from their customers chests of plate, jewels, specie, deeds, and policies, of all sorts for the sake of safe custody in their strong rooms. In this capacity they act simply as warehousemen for their customers, and no property of any description passes to them in the goods deposited, and they have no lien over these deposits, for the balance is due to them from their customers on their accounts. And as these goods are only placed with them on trust, the statute of limitations does not apply, for the statute never operates against a trust. It is said that several London bankers have plate and jewels deposited with them by the refugees in the French Revolution. The real owners perhaps perished in the Revolution, and their heirs have never claimed their valuables on a banker's lien on his customers' securities. 6. A banker's general lien is part of the law merchant, and is judicially noticed as such. A banker has a general lien over all securities deposited with him by his customer as a banker, for debts due to him by his customer without any specific appropriation. But he has no lien over securities placed in his hands for a special purpose. If he receives securities in such a way he undertakes to do what he is requested, and such an undertaking is quite inconsistent with the notion of a lien. If a banker takes a security payable at a future day, his lien is gone. For taking the security payable at a distant day, is payment pro tempore, and an extinction of the debt, and no new debt arises until default is made in payment of the new security. The bankruptcy of a customer. 7. Directly a customer becomes bankrupt, he is commercially dead, and he has lost all power to deal with his property, which is gone to his creditors. Consequently a banker may receive money on a bankrupt customer's account, because he does as trustee for the creditors, but he must not pay away any money to his customer's order, and if he does so, he will have to refund it to the creditors. He may retain any security he holds for any debt to which it is specially appropriated, but he is the trustee of the creditors for any excess. If a banker pays any of his customers' checks after he has notice of his having committed an act of bankruptcy, he will have to refund the money and will not be allowed to prove for the amount on the appropriation of payments. 8. If a customer keeps several accounts with a banker, and is indebted to him, he has a right to say to which of them any money he pays in shall be appropriated. But if he makes a payment generally, the banker has the right to appropriate it to which he pleases, and may take reasonable time to determine which. On banking instruments of credit. 9. A banker buys money and securities from his customers, and gives them in exchange for it his own credit. This credit or debt is expressed either in the form of an entry in his books called a deposit, or the banker may give him a written document in various forms, such as a bank note, deposit receipt, a draft on his correspondence, circular notes, and letters of credit. By the common law of England any person may issue his promissory note in any form payable to bearer on demand, payable to order, or at sight, or after demand, or at any certain event, and for any amount. In the middle of the last century a considerable number of bankers issued their notes for small sums such as 5 or 10 shillings, and for £1, but by a statute in 1775 all persons were forbidden to issue notes payable to bearer on demand for less than £1, and by a statute in 1777 a similar prohibition was enacted against all notes under £5. By the 7 and 8 Vict. 1844, c. 32, sg. 10, 11, 12, no person may become a party to an obligation payable to bearer on demand in any part of the United Kingdom, except those bankers who were lawfully issuing their own notes on the 6th of May 1844. A banknote is defined by statutes 17 and 18 Vict. 1854, c. 83, s. 11 to be any bill, draft, or note, other than notes of the Bank of England, which shall be issued by any banker, or the agent of any banker, for the payment of money to the bearer on demand, and any bill, draft, or note so issued, which shall entitle, or be intended to entitle the bearer or holder thereof, without endorsement, or without any further, or other endorsement than may be thereon at the time of issuing it, to the payment of any sum of money on demand, whether the same shall be so expressed or not, in whatever form and by whomsoever such bill, draft, or note shall be drawn or made. The following establishments only may issue obligations payable to bearer on demand in England. 1. The Bank of England. 2. Private banking firms which were lawfully issuing their own notes on the 6th of May 1844, and which have not become bankrupt, or discontinued such issue since that date. 3. Joint stock banks formed under the 7 4, 1826, c. 46 issuing their own notes at a distance not less than 65 miles from London. Tender of payment in country bank notes is good if not objected to on that account. Even if a banker tender his own notes which are afterwards dishonoured. If country bank notes be taken in payment of goods at the time of the sale, and as part of the contract, so that no debt is created, and without endorsement, the vendor takes them at his own risk, and has no remedy against the transferor if the banker fails, before he has obtained payment of them. But if the transferor knew at the time he offered the notes in payment that the banker had failed, he is liable. But if the notes be taken, not at the time of the exchange, but in payment of a pre-existing debt, however short a period has elapsed between the creation of the debt and the tender of the notes, if the transferee present the notes within due time, and find that the banker has failed, and give due notice of dishonour to the transferor, he may demand payment of his original debt. If a customer pays into his account with his banker the notes of another banker, for which his banker gives him either credit in account or a deposit receipt, and if the banker on duly presenting the notes for payment finds that the banker who issued them has failed, and if he gives due notice of dishonour to his customer, he may cancel the credit. But if instead of demanding payment of the notes he takes a credit in account with the banker who issued the notes, that is equivalent to payment, and he is liable to his customer, if the other banker fails. If one person changes a banknote as a favor for another, and if on duly presenting the note for payment he finds that the banker has failed, and if he gives due notice of dishonor, he may demand back his money on checks. 10. A banker invariably buys money and securities from his customer by creating a credit in his favor. This credit is termed a deposit. By the custom of bankers, the contract between a banker and his customer having an ordinary drawing or current account with him, is to pay on demand, either to him or to anyone else to whom the customer may assign them, whatever funds he may have at his customer's credit, within a reasonable time after he has received them, and to accept his customer's bills to that amount. By the custom of bankers, possession of funds is equivalent to acceptance, and admission of funds is a legal acceptance of a check drawn by a customer. A verbal promise to pay, or a collateral writing promising to pay, or any mark such as initials placed on a check, the well understood meaning of which is a promise to pay, is a legal acceptance by a banker having funds of his customer. A check is payment unless dishonored, and tender of payment by check is good unless objected to on that account. When a customer has placed securities in the hands of his banker, and is allowed to draw against them in a certain well understood way, the banker cannot change the well understood course of dealing, and dishonor his customer's checks without giving him notice. A banker who pays a check must cancel it by crossing out the drawer's signature under a penalty of £50. Paid checks are the property of the drawers, who may demand them back at any time, unless there be overdrafts, for then the banker has a right of action on them. If a banker cancels the drawer's signature to a check, and if before actual payment he discovers any reason why he should not pay it, he may withhold payment. But if the money be actually paid over to the presenter of the check, even in mistake, the property in the money is gone from the banker, and he cannot retake it. Checks are within the summary procedure on Bills of Exchange Act, 19 and 20 Vict. 1856, c. 67, and may be taken in execution. If a check payable to order bear an endorsement purporting to be that of the payee, the banker is not bound to inquire into its genuineness, and an endorsement by procuration is within the meaning of the Act. A check is the assignment of a chosen action, and when communicated or notified to the banker by the holder is a complete assignment of the fund. If a check be notified to the banker, and the drawer dies before it is paid, the holder is entitled to payment. If a banker pays a check with a forged signature, the loss falls on him. So if the body of the check be written by his customer, and fraudulently altered by another person, so as to be payable for a larger sum than originally drawn, and the banker not detecting the alteration is it, he must bear the loss of the excess. But if the customer authorizes another person to write the body of the check, and that person fraudulently alters the check so as to make it payable for a larger sum than authorized, and so the body of the check is all in the same handwriting, the banker will not be liable. If banker pays a check under circumstances which are evidently suspicious, he must bear the loss. A banker must pay his customers' checks strictly in the order in which they are notified, communicated, or presented to him for payment. He must debit his customer's account with checks on the day they are notified to him or paid, and not on the day they are drawn. Sums paid by a banker extinguish the debts created by sums paid to him in strict chronological order. If a banker having funds of his customer wrongfully dishonors his check, or bill made payable at the bank, so that the customer suffers damage, he has an action against the banker for such damage. But such special damage must be laid and proved. If the customer becomes bankrupt in consequence of the wrongful dishonor of his check, his assignees have an action against the banker. The holder of the check or bill may sue the banker on the instrument. A check may be presented any time within 6 years of its date to charge the banker, and the drawer if the banker fails. The transferee of an overdue check is not subject to the equities of the transferor, as the transferee of an overdue bill. If a customer has an account of a fiduciary nature, such as trustee, executor, or otherwise, a banker may not refuse to pay his checks because he may believe that the customer intends to apply the funds in a breach of trust. And he will not be liable to the Sestuic Trust if he is not privy to the breach of trust. But if he acts in concert, agreement, and collusion with his customer in committing the breach of trust, and especially if he obtains some benefit by it, as by his customer paying a debt of his own to him by means of checks on the trust account, he must replace the trust fund. The statute of limitations does not apply to a banker misapplying a credit in account, or deposit. If taken instead of money, is good payment. If a banker supplies his customers with checks with a crossing in blank printed on them, the customer before he issues the check, may write the words "pay cash" on it. This being done before the check is issued, nullifies the crossing, and the banker may pay cash across the counter. If a banker, either at the request of a customer, or when a check is presented by the holder or his agent, place a mark upon it, as by his initials, signifying that the check is good, and will be paid, such mark is a legal acceptance of the check by the banker. If a banking company has several branches, each with its own customers and accounts, each branch is considered an independent bank for the purpose of receiving and transmitting notice. Each branch must collect its own checks and bills, and time will not be enlarged so as to permit it to collect them through its head office. If a person change a check as a favor for another, and if the check be duly presented and dishonored, he may give notice of dishonor and recover the money. Our letter of credit is a written request addressed by one person to another, requesting the latter to give credit to person named in it. If the request be unconditional, it is termed an open credit. If the request be on the condition that bills of lading be deposited as collateral security, it is termed a document credit. A marginal letter of credit is one by which a person named in the margin guarantees to another person that he shall receive credit from or have his bills accepted by a third person. The holder of a banker's circular letters may demand payment of them from himself, as well as from his correspondents abroad. But he is not bound to cash them unless they are returned to him, or he receives an indemnity. On banking investments. 11. Though a banker is bound theoretically to repay everyone or his customers instantly on demand, yet as no man whatever would spend all his money if it were in his own possession, but would keep a store of it, and spend it gradually, so when he keeps it at his banker's, he will not be likely to require it all at once, but will keep a store of it there, just as he would have done if he had kept it at home, and the banker is able to trade with it in a variety of ways. if he takes care to keep by him sufficient to meet any demand his customers are likely to make on him. The different methods in which a banker trades with the money left with him by his customers depend very much the class of his customers and their occupations and the general business of the locality he lives in. He must adapt his business in such a way as may be most suitable for the class of customers he has to deal with, so that he may never fail for an instant to meet any demand. If his customers are chiefly country gentlemen, whose rents are remitted regularly, and who draw them only for family expenditure, he may calculate pretty accurately on the demand likely to be made on him, and he may lend out his funds on more distant securities than are proper to other cases. Such are chiefly country bankers in agricultural districts and those at the West End of London. But when a banker does business in a trading community who are in constant want of their money, and whose demands are much more frequent and unexpected, he must adopt a very different line of business. He must then have his funds within reach at a very short notice, and he ought to have them invested in such property as he can sell on a very short notice, to meet any unexpected pressure on him. The business of such a banker will chiefly consist in discounting bills of exchange, and is of a distinct nature from that of lending money on mortgage. We must now consider the various methods in which bankers trade. They are: 1. By discounting bills of exchange. 2. By advancing to their customers on their own promissory notes, with or without collateral security. 3. By means of cash credits or overdrawn accounts. 4. By lending money on mortgage. 5. By purchasing public securities, such as stock or exchequer bills. On discounting bills of exchange. 12. We have already fully explained the nature and meaning of discounting bills of exchange. Here, therefore, we have only to make some practical observations on the subject. If an abundant supply of good bills were always to be had, they are, no doubt, the most eligible of banking investments, for their date is fixed, and the banker always knows when his money will come back to him. He charges the profit at the time of the advance, and he gains it whether the customer draws out the money or not, and in a large bank it must often happen that drawers, acceptors, and payees are all customers of the same bank, so that when the drawer has his account credited with the proceeds of the bill, and gives a check on his account, in many cases it must happen that the check finds its way to someone who is a customer of the same bank, and, therefore, the bank has reaped a profit by creating a credit which is simply transferred from one account to another. And the same results take place much more frequently by means of the system of clearing explained presently, by which all the banks that join in it, are, in fact, but one great banking institution. If it should happen that a customer of one of the clearing banks gives a check to the customer of another, the chances are that some customer of that other bank gives a check to the customer of the first, and these claims are simply readjusted to the several accounts without any demand for coin. The more perfect the clearing system, the less coin will be required. Consequently, the greater part of banking profits are now made simply by creating credits, and these credits are paid not in cash, but by exchanging them for other credits. When a banker discounts a bill for a customer, he buys it, or purchases it, out from him and acquires all his customers' rights to it, that is of bringing an action against all the parties to it, and also of reselling it again if he pleases, or rediscounting it. And this is one of the great advantages of discounting bills, that if there is an unusual pressure for cash on the banker, he can resell the bill he has bought. We have observed that discount is more profitable than interest, and the profit rapidly increases the higher discount is. A very slight consideration will show this. Suppose a money lender advances money at 50% interest. He would advance his customer £100, and at the end of the year receive his £100 back, together with the £50. His profits therefore would be £50%. But suppose he discounts a bill for £100 at 50%. He would only actually advance £50, and at the end of the year he would receive £100. Consequently he would make a profit of 100%. The following table shows the difference in profit in trading by way of interest and discount. Table showing the profits percent. and per annum at interest and discount. Interest, discount, interest, discount. The system of discounting bills is intended to be the sale of bona fide debts for work done, or for property actually transferred from one party to another. And there is nothing that requires more sleepless vigilance on the part of the banker than to take care that the debts he buys are genuine and not fictitious. When bills are offered for sale, he ought to know whose debt it is that he is buying, and he ought to be able to form some conjecture as to the course of dealing between the parties, which could give rise to the bill. Bills should not only be among traders, but only according to a particular course of trade. We will speak of real debts in the first place, and these may arise in a number of different ways. First, between traders in the same business, and, secondly, between traders in different species of business, but yet for work done. If we take the case of manufactured or imported goods, there are usually three stages they pass through. 1. From the manufacturer or importer to the wholesale dealer. 2. From the wholesale dealer to the retail dealer. 3. From the retail dealer to the consumer. Each transfer of property may give rise to a bill, but of these the first two are by far the most eligible, and are most peculiarly suitable for a banker to buy. The third should only be purchased with great caution, and but rarely. There are other cases of good trade bills, when one business requires the supply of different productions, such as a builder requires wood, lead, slates, bricks, and other materials. Hence a bill of a wood merchant, or a lead merchant, on a builder, would be a very natural proceeding, and apparently a proper trade bill. So if a builder fits up premises for a shopkeeper or merchant, a bill for the work done is a legitimate trade bill. All these bills therefore follow the natural course of trade, and carry the appearance on them of being genuine. But if a banker sees bills drawn against the natural stream of trade, it should instantly rouse his suspicions. Thus a bill drawn by a wholesale dealer upon a manufacturer, or by a retail dealer on a wholesale dealer, would be contrary to the natural course of trade, and should arouse suspicion. A bill drawn by a lead merchant on a builder would be proper on the face of it, if there were nothing to excite suspicion, but a bill of a builder on a lead merchant would be suspicious, unless it was satisfactorily explained. Bills of persons doing the same trade upon each other are suspicious on the face of them. Thus a bill of one manufacturer upon another in the same business, or between one wholesale dealer and another, are evidently suspicious, because there is no usual course of dealing between them. Besides, such bills are chiefly generated in speculative times, when commodities change hands repeatedly on speculation that the prices will rise. Bankers should be particularly on their guard against buying bills drawn against articles which are at an extravagant price in times of speculation. A banker is prima facie influenced by the respectability of his own customer, who is the drawer or endorser of the bill. He ought however to acquire specific information regarding the persons upon whom his customers are in the habit of drawing, and satisfy himself that they are likely to be genuine bills. And this vigilance should never be relaxed in any case whatever. We hold it to be utterly contrary to all sound banking to take bills merely on the supposed respectability of the customer. But we believe it to be far too common a practice to look merely to the customer's account. Customers begin by getting the character of being respectable. They bring perhaps good bills at first and keep good balances, and their bills are punctually met. This regularity and punctuality are very apt to throw a banker off his guard. He thinks his customer a most respectable man doing a good business. All the bills are taken to be trade bills. By and by the customer applies for an increased discount limit, on account of his flourishing business. The banker is only too happy to accommodate so promising a customer. His discounts swell and his balances diminish, but still his bills are well met. However, the time comes, perhaps when the banker thinks it prudent to contract some of his accounts, and this may be one which he thinks it expedient to reduce, and then, perhaps he makes the pleasant discovery, that there are no such persons at all as the acceptors, and that the funds for meeting all these bills have been got from himself. Such cases as these are not unlikely to happen when London houses supply small country tradesmen and draw upon them. When a man has established a good character, it is impossible to require information about every bill before it is discounted, but we do not hesitate to say that it is of the first importance that banker should be constantly probing his customers' accounts, and get information of the persons they draw upon. It was wittily said by someone, Lord Halifax we believe, that man in this world is saved chiefly by want of faith. This is eminently true of banking. A banker should be the most suspicious of mortals. He should have implicit faith in no man. The amount of villainy and rascality which is practiced by means of accommodation and fictitious and forged bills would exceed belief, if such disclosures were made public. However, it is contrary to the policy of bankers to allow it to be known how they are robbed and cheated. Their interest covers a multitude of sins. If criminals were prosecuted according to their merits, the calendar would swell up to a frightful extent. There is, probably, no class of persons who see felonies committed so frequently as bankers, and are necessitated to let them go unrepressed and unpunished. And there is reason to fear that such things are encouraged by the too easy faith reposed in their customers by bankers. If bankers laid out more expenditure in the intelligence department, we believe it would be amply repaid, and many would have been cut short in a career of crime, of accumulated robberies, which generally terminate in disaster to the bank. As it is contrary to all sound principles of banking to discount bills solely on the customer's respectability, as appearing from his account, so any customer should be regarded with suspicion who is not ready and willing to communicate information to his banker about his affairs. If he will not do so, how can he expect him to give him assistance in the day of trouble? Some customers, however, are mightily indignant if their banker will not discount their bills on the strength of their names, without regard to the acceptor. But as such a practice is contrary to sound banking, so it will invariably be found that these are not desirable customers to have, and it would be well for a banker quietly to shake off his connection with them, as in the long run, they will probably bring him more loss than profit. So much for discounting bills of exchange, which consists of buying debts, and not lending money. A banker, however, may not always be able to find a sufficient quantity of eligible debts to buy, to absorb all his disposable funds, or he may not choose to employ them all in that way, and some of his customers may want a loan on security, who have no bills to sell. The banker takes his customer's promissory note for the sum payable, at the date agreed upon, and also a deposit of the convertible security as collateral. He does not advance on the goods or security itself, that is the business of a pawnbroker, but on the personal obligation of his customer, and the securities are only to be resorted to in case of the failure of his customer to pay his debts. These convertible securities are chiefly public stock, bank stock, India bonds, shares in commercial companies, dock warrants, bills of lading. Whenever he takes any of these as collateral security, he ought to have a power of sale from his customer in case he fails to discharge his obligation. These loans, though they may be sometimes made to respectable customers, are not desirable advances for a banker to make, and he should be chary in encouraging them too much, for they frequently are demanded from the borrower having locked up too much of his funds in an unavailable form. There is then the danger of the obligations not being paid at maturity, and then come requests for renewals, and the banker is either driven to the unpleasant necessity of realizing the security, or else having his temporary advance converted into a dead loan. Persons who seek for such advances habitually are most probably speculating in joint stock companies' shares. They buy up shares on speculation, which they hope will advance in price. They then wish to pledge the shares they have already bought to purchase more. Then perhaps a turn in the market comes, and the value of the securities goes down rapidly. They are unable to pay their note, and the banker may perhaps have to realize the shares at a loss. During the railway mania of 1845, a number of banks, called exchange banks, were founded expressly on this principle of making advances on joint stock companies' shares, especially railway shares. But they were all ruined, and some of them, we believe, suffered frightful losses from the great fall in the value of railway stock. The objection to such transactions in a banking point of view is that the promissory notes of these persons and their securities are not available to the banker in case he is pressed for money. Moreover, they are barren, isolated transactions, which lead to nothing, whereas a discount account promotes commerce, and grows more profitable as the business of the customer increases. There is also a very important point to be considered in the shares of many companies which are offered as collateral security, that by the deeds of the companies, no property in the shares passes, except by the registration of the name of the holder in their books. Now, while the customer is in good circumstances, there may be no danger, But if he becomes bankrupt, the banker is not entitled to retain the shares against the other creditors. If the bankrupt is the registered owner of the shares, his creditors are entitled to them. Hence, if the banker means to complete his security, he must have himself registered as the owner of the shares, and thereby becomes a partner in a multitude of joint stock companies, of whose condition he can know nothing. Then perhaps, calls are made, and the banker finds that instead of buying a security, he has bought a liability, and he must pay up the calls or forfeit the shares. All such advances, therefore, should be made very sparingly, and only with such surplus cash as the banker may not be able to employ in buying good bills, and they should only be made to such persons as he believes to be perfectly safe without the deposit of the security. No banker would make such an advance if he really believed that he would be obliged to realize the security to repay himself, as such proceedings will always make a soreness between himself and his customer, who will be averse to seeing his property sold at a sacrifice, as he may call it. Advances on dock warrants and other similar securities, are also liable to many similar objections, and should be very sparingly done, as they subject a banker to much trouble beyond the line of his proper business, and are indications of weakness in a customer. Some customers will expect to have loans upon leasehold or freehold property left as security, but these are most objectionable as collateral security. The process of realizing freehold property is so long, uncertain, and tedious that it is perfectly unavailable to a banker in case of necessity. In fact, we believe the best rule in all cases of loans with collateral security, except in such instances as public stock, is to avoid, as much as possible, making them to anyone who is not perfectly good without them. The objection to cash credits on the part of London bankers is exactly similar to that against advances on mortgage, that in time of pressure it is very difficult to call up the advances, and the securities are not generally realizable. But if cash credits are objectionable, still more are purchases of foreign securities, such as stock in foreign railways. Several of the joint stock banks which failed in 1857 and 1866 sinned grievously in this respect of locking up their funds in foreign securities. If temporary loans on real property are objectionable as securities to city bankers, much more so are mortgages, which are intended by their nature to last for years. Such transactions are, therefore, chiefly confined to country bankers, and those at the West End of London, whose connections lie more among the landed than the commercial interest, and who are not liable to be called upon so suddenly for cash. Besides these operations, all of which are founded upon personal liability, all of which contain personal obligations to pay fixed sums of money and are therefore dealings in currency, bankers usually invest part of their funds in public securities, which are supposed to be more readily convertible into cash than others. Public securities are of two descriptions: the one currency, or securities for money, such as exchequer bills; the other property, or convertible securities, such as the funds, the former being an engagement on the part of the exchequer to pay a certain sum of money, like any other bill, and the latter being no engagement to repay any fixed sum at all, but only a fixed rent, or sum, for its use. Each description of public securities has its advantages and disadvantages. The interest on the funds will be found, in the long run, to be higher than those on other descriptions of public securities. But there is this serious consideration, that the value of these stocks is very fluctuating, and when any public crisis comes, and bankers wish to sell their stock, they may sustain very great loss. In the week of the great crisis of 1847, when many banks had to sell stock to provide for contingencies, the losses were immense when they bought in again to replace it, and this danger is greatly aggravated by the Bank Act of 1844. Another disadvantage regarding stock is, that all transactions of bankers must become known, as they have to transfer it. Exchequer bills have this advantage, that a banker can deal in them without its being known to anyone but the broker. Exchequer bills being like any other promissory notes, an engagement of the government to pay a definite sum of money, it is not probable that the banker can ever lose so much on them as on stock. In order to prevent exchequer bills falling to and discount, they always bear interest, and, in consequence of this, are usually at a premium, and when by the change in the market rate of interest, they fall to a discount, the interest upon them is usually raised from the circumstance of their greater steadiness in value. The profit of investing in exchequer bills is less than that from stock. Bankers collect money from those who have it to spare, and advance it, or its equivalent, to those who require it. They may sometimes themselves be in a similar predicament. Sometimes they may have more by them than they have employment for. Sometimes from unusual demands, they may be in want of temporary advances. There is a class of persons who undertake this equalizing process. The bill brokers. They go the round of the bankers every morning, and borrow from those who have to lend, and lend to those who want to borrow. At the present day, the principle of association has been developed to a much greater degree than ever it was before. Companies are formed for all manner of purposes. When these companies apply to open an account with a banker, it will generally be found that they want accommodation. But a banker should never accommodate a company of whose affairs he can know very little. He should only grant accommodation on the personal liability of the directors. He should require from them a joint and several note, payable on demand, reserving his right against the company, only as a collateral security. If anything goes wrong with the company, he has an immediate remedy against the directors. Whereas if the company goes into the winding up court, it will be a long time before his claim can be settled, and then there may be some technical objection. The contributors may say that the directors had no right to draw bills by the constitution of the company, or that they may have exceeded their power, and then he may have to contest his claim through several different courts, bringing him nothing but vexation and anxiety. On the clearing system. 13. Suppose that any number of the customers of the same bank have transactions amongst themselves, and give each other checks on their accounts. Then, if the receivers of the checks do not actually draw out the money, any amount of transactions may be carried on by simple transfers of credit from one account to the other without a single piece of money being required. The clearing system is a device by which all the banks which join in it are formed into one huge banking institution for the purpose of transferring credits from one bank to another, just in the same way as credits are transferred within the same bank. The clearing system arose in this way. Every London banker has every morning claims against most of his neighbours, and of course most of his neighbours have claims against him. It used to be the custom for every banker, the first thing in the morning, to send out a number of clerks to collect the claims he had against his neighbours, who of course were obliged to keep cash or notes to meet them. The metropolis is portioned out into districts called walks, and each clerk had to collect all the bills, checks, and see. Within his walk, these claims are called bankers' charges, and were paid in bank notes, in some cases by checks drawn upon the Bank of England. This clumsy and barbarous method of settling bankers' charges caused a great waste of bank notes. Every banker had to keep by him a sufficient amount of bank notes to meet the charges of all his neighbours. It was stated in evidence before the House of Commons that one bank alone was obliged to keep £150,000 in notes for this sole purpose. And if this bank alone was obliged to keep this quantity of notes for this unprofitable purpose, what must have been the total amount wasted in this manner by all the banks? About 1775, the inconvenience of sending out to collect these charges led a number of the city bankers to organize an exchange among themselves, on a similar plan to that already practiced by the Edinburgh banks. They engaged a room in which their clerks met and exchanged their mutual claims against each other, and paid only the balance in cash, or bank notes. The Bullion Report says that in 1810 there were 46 bankers who cleared, and that the average amount of checks, bills, and which passed through the clearing house every day was about £4,700,000, and that all the balances on this account were settled by about £220,000 in bank notes. In 1854 the joint stock banks were admitted to the clearing house, and in 1864 the Bank of England. The mode of doing business is as follows. The bills and checks which each banker holds on the other clearing banks are sorted in separate parcels, and at 10:30 a clerk from each bank arrives at the clearing house. He delivers to each of the other clerks the obligations he has against his house, and receives from each clerk the obligations due from his own. When these obligations are interchanged, each clerk returns to his own bank. The same process is repeated at 2:30. Each bank has till 4:45 to decide whether it will honor the drafts upon it. If it does not return any drafts upon it before that hour, it is held to have made itself liable on them to the clearing house. At 4:45 the business closes and the accounts are made up, and so admirable is the system that not a single banknote or sovereign is required for the settlement of the claims. Each clearing bank keeps an account at the Bank of England, and the inspector of the clearing house also keeps one. Printed lists of the clearing banks are made out for each bank, with its own name at the head, and the others are placed in a column in alphabetical order below it. On the left side of the names is a column headed debtors, and on the right side a column headed creditors. The clerk of the clearing house then makes up the accounts between each bank, and the difference only is entered in the balance sheet, according as it is debtor or creditor. A balance is then struck between the debtor and creditor columns, and the paper delivered to the clerk, who takes it back to his own bank. The balance then is not paid to, or received from, the other bankers as formerly, but it is settled with the clearing house, which keeps an account itself at the Bank of England. The accounts are settled by means of a species of cheque appropriated to the purpose, called transfer tickets. They are of two colours, white and green. White, when the bank has to pay a balance to the clearing house; green, when it has to receive a balance from it. By this admirable system, transactions to the amount of many millions daily are transferred from one bank to another, without the use of a single banknote or coin. In the course of last year, credits to an amount exceeding £6 billion were thus interchanged between the clearing banks. In most country towns of any size a similar system of exchanges is organized, and the difference is settled by a draft upon London, and in 1860 a clearing establishment was instituted in London for country bankers. All these institutions have the tendency to constitute, as it were, all the banks in the kingdom into one vast banking institution, and to transform the monetary business of the country into mere transfers of credit, without the use of banknotes and coin.